Welcome back to One Stop Law. Now, in this video, we will look into the various essential elements of a valid contract. Now, under Section 10 of the Indian Contract Act are provided some basic elements which are absolutely essential to result in a valid contract. But those elements under Section 10 are not enough. So, we will look into Section 10 and along with it all other sections which lay out the essentials for a valid contract. So, without further ado, let's get started with the video. First of all, let us look into the provision of Section 10. Now, Section 10 lays down that all agreements or contracts, if they are made by free consent of the parties competent to contract for a lawful consideration and with a lawful object and are not expressly declared void. So, from this definition under Section 10, we are getting some essentials like there must be an agreement, there must be free consent of the parties must be competent to contract, they must do this contract for a lawful consideration and for a lawful object, and the agreement should be such which is not expressly declared void under this Contract Act itself. But this Section 10 is not complete and exhaustive, and there are certain other sections under the Indian Contract Act which provides for more requirements for an agreement to be enforceable under law. We know an agreement which is enforceable by law is a contract. So let us now look into all the essential elements which are required to form a valid contract as per the provisions of the Indian Contract Act. The very first essential for a valid contract is that there should be a valid offer and a valid acceptance made between two parties. Okay, so minimum requirement is two parties. There must be two parties who must form a valid agreement. An agreement will be valid if there was a valid offer, that is, offer has all its essential ingredients, and that offer must have been accepted unconditionally by the other party to whom it is made. Okay, so one party should make an offer and the other should be accepting it. The terms of the offer must be definite and the acceptance of the offer must be absolute and unconditional. The acceptance must also be made in the mode prescribed by the person who has made the offer, and it must be communicated to the offerer in the prescribed mode. Okay, an offer, an acceptance or offer, unless it is communicated, is not considered to be a valid offer or acceptance or resulting in a valid agreement. So you see all the sections under the Indian Contract Act which deal with all these things, that is a valid offer, acceptance and resulting in a valid agreement, are sections 2 clause A, section 2 clause E, section 3, 4, 7 and 8. The second essential ingredient of a valid contract is there must be an intention between the parties to create a legal relationship. That is, the parties who enter into this agreement must have the intention to form a legal agreement and nothing else. That is, if the parties had a mere intention of forming a social agreement, a domestic agreement, or say a family agreement kind of thing, then that agreement is not enforceable under law and that is not considered as a contract. Now, what do we specifically mean by a legal agreement or intention to create legal relationship? Let us say that suppose you invite your friend for a dinner at your house one day, okay, and maybe the friend is very excited for having the dinner with you, but for any reason you yourself just forget about the thing. Okay, you go out with some other friends, and when your friend turn up in your house at that night, he finds that the door is locked and he doesn't get the dinner he was expecting from you. So now, can your friend, this friend whom you invited, who could not have that dinner at in your house, will he be able to go to the court and sue and get compensation from you or get it enforceable by any means? No, because the agreement between you and your friend was merely a very social agreement kind of thing. There was no intention between both of you to create a legal relationship out of it. Okay, there's a very famous case of Balfour versus Balfour in this regard. I will do the case law separately in some other video, but as of now, another most essential ingredient of a valid contract is that the parties must have clear intention to form a legal relationship and nothing, and no other relationship like a mere domestic arrangement between husband and wife, or as the example I gave you, between two friends. This kind of relationship, this kind of agreements are not enforceable under law as contracts. The next essential ingredient for a valid contract is that there should be a lawful consideration between the parties. Okay. Now, what is a consideration? Consideration means some benefit moving from one party to the to another in a contract. Basically, consideration means something in return. So, if for example, in a contract, A promises to sell his house to B, say for rupees 50 lakhs. So here, what A is giving to B is his house, and in return what B is giving, that is 50 lakh rupees. So A is giving the house for which he is getting a consideration, that is 50 lakh rupees. Now this is a lawful consideration, and for any contract to be enforced, any agreement to be enforceable as a contract, the consideration must be lawful. Any unlawful consideration makes the agreement unenforceable. What can be an unlawful consideration? Take this very example. In this case, A was giving his house to B for, say, in exchange of certain money, that is 50 lakh rupees. Just take another example. A agrees to give his house to B. In return, B will suppose give him certain certain quantity of some prohibited drug. Say B will supply A 50 quintal of opium. Now this is completely unlawful consideration which will be flowing from B to A, and therefore it makes this agreement unenforceable, and this contract, it is not a valid contract. Okay. The next ingredient we have is the capacity of the parties, basically their competency. That is, parties to the agreement must be competent enough to enter into a valid contract. Now, sections 11 and 12 of the Indian Contract Act lays down the competency of the parties, like what makes a party competent to enter into a contract. And if we analyze those provisions, we see that every person is competent to make a contract if he is of the age of majority. Okay, that is, as per the Indian Majority Act, the person has attained the age of majority, that is 18 years. Number one, if the person is of sound mind, this is the second condition, that is, the person should be of sound mind, he should not be unsound. And the last is number three, that he is not disqualified from contracting by any law to which he is subjected to, that is, the person is not otherwise disqualified. Now this otherwise disqualification may include in any case of where the person has been declared an insolvent by the court of law. Insolvent means his existing debts are more than the property he is having. If the person is a convicted criminal, he is undergoing some sentence of punishment, then the person may be disqualified from entering certain kinds of contracts. So what we see here, that a minor, an unsound person, a lunatic, an insolvent person, a convicted person are the persons who are not competent, who are not considered to have the required capacity to enter into a contract. The next essential ingredient to form a valid contract is, of course, the free and genuine consent of the parties who are making this agreement. Okay, now see, consenting means the term consent has been defined under section 13, which means to consent to something, to assent to something, meeting of minds. But that consent must be free and should not be forced or induced by some other factors. Now I have made extensive videos on all the factors vitiating a valid consent. You can go through them in my previous lectures. So consent of the parties is said to be free when they are given by the parties voluntarily and out of their own will, and there is absence of any of those factors mentioned under section 14 which cause that consent. That is, the parties give this consent freely and not caused by under any coercion, undue influence, fraud, misrepresentation or mistake. Okay, and just remember one thing, if a person's consent to the contract is not free and it is caused by any of the first four factors, that is coercion, undue influence, fraud and misrepresentation, then the contract does not become void, rather it becomes voidable. Voidable means the party whose consent to the contract was not free, he can anytime go to the court and get it declared void. Until and unless this person goes to the court and tells the court that, see, my consent was obtained by this mode, Till then, the contract remains valid. This person has to go to the court and get it declared void, and that is why such contracts are known as voidable contracts. Now I will stop this video here. In this video we have learned about the first 5 essential elements of a valid contract, that is a proper offer and acceptance between two parties resulting in an agreement, intention to create a legal relationship between the parties, capacity of the parties or their competency to enter into a contract, lawful consideration, and the effect of free consent, necessity of free consent in the contract. In our next video, we will continue with the rest of the essential elements and we will discuss the rest of 5 of them. Thank you all.